A warm welcome to the first 3CL seminar in Lent. As you know, my name is Felix Steffek. I'm the 3CL director, and I'm very proud and happy that today I'm in the position to present Associate Professor John Sorabji of UCL London. He came up to speak on modernizing commercial dispute resolution. John has an illustrious and distinguished career already behind him. He served in particular as principal legal advisor to the Lord Chief Justice and the Master of the Rolls. He has held multiple visiting professorships, in particular at the Université Panthéon-Assas, and he very recently served as Deputy Private Secretary to the King. On the topic, he is a real expert. Most recently, he has advised the Consultative Council of European Judges on an opinion on the use of assistive technology and AI in the judiciary. He's currently working on a book called Model Codes of English Civil Procedure. And against his background also that is one of working as a barrister, John really has all the ingredients and the experience to speak to us on modernizing commercial dispute resolution. John, I'm very grateful that you made the way up, to rainy Cambridge from London. It's great to have you here. It's really a really important topic for the UK in particular. After Brexit, perhaps looking for its role in the international landscape, where the UK stands in terms of perhaps becoming a hub for commercial dispute resolution and how that could work. And of course, it is technology that is driving strategy and considerations, both in practice, but also for those making policy. John, thanks a lot again. We're very much looking forward to your presentation. As always, we'll first have a presentation and then followed by discussion and comments. So thank you very much for joining us today, and over to you, John. Thank you.
Thank you very much, and well, it's nice to be here, despite the weather, which almost stopped me, but there you go. So I'm going to talk about modernizing commercial dispute resolution today. So what am I going to talk about precisely? So I'm going to look at four things. First of all, I'm going to just give a little bit of background in terms of England and Wales as a centre for commercial dispute resolution, a CDRC, a Commercial Dispute Resolution Centre. I'm going to look a little bit at the historic position, how we got to where we are, then some of the current challenges that we've got, before looking at how we may modernise the system, or what kind of steps we might need to take to do so. So that's a broad outline of what I'm going to talk about over the next 25 minutes, I think, or so. Yes, 25 minutes. Okay. So, as a starting point, if we go back to the early 1970s, we weren't that shy about advertising how fantastic we were, or at least the judiciary were, in terms of England as a dispute resolution centre. So here we have Lord Denning, who you may have heard of, at least used to be popular at one time, talking about England as a forum for dispute resolution. The phrase that he used, it's a good forum, a good place to shop in. If companies, businesses, which could resolve their disputes in any number of jurisdictions, whether it's France, whether it's Hong Kong, whether it's Singapore, whether it's Stockholm, if you're looking at arbitration, whether it's New York, they would come here for a variety of reasons. We were a good place to shop in if you were a business that had a dispute. He identified two reasons for this: quality of the goods. What did he mean by that? He meant the legal profession and the judiciary. I'm going to talk about that in a moment. And also the speed of the service, which I think even in the 1970s was slightly untrue. The speed of the service in any jurisdiction where you're thinking about dispute resolution in the courts is never speedy. It's a question of just how slow are you in comparison to the lack of speed in other jurisdictions. So speedy by comparison, not an absolute. But identified two reasons. But more broadly, why was England and Wales viewed, or why has it been viewed, as a good forum for dispute resolution, particularly commercial disputes? And the first reason that has been identified, and there was a study which came out around about 3 or 4 years ago now by a scholar called Themelli in a book called The Great Race of Courts. And he identified a variety of empirical reasons why England and Wales might be viewed as a good forum to shop in. And the first was English as a language. It was a common language used in business. It was a common language used by international lawyers. And as a consequence, linked to English contract law, English commercial law, it was the language in which business and disputes were conducted. So it provided a good incentive or a good basis to litigate within England and Wales. And we can perhaps see now the advantage, or at least the benefit of the English language, at least perceived to be in terms of dispute resolution, existing because we see in commercial courts which are being developed in other countries and which have been developed, for instance, in France, in Germany, in the Netherlands, their commercial courts, particularly those that focus on international disputes, offer English language as a means to which they can litigate. So if you want to litigate there, you can litigate specifically in English as well. So they're using that common business element as a basis on which you can litigate. So that was the first reason. Second reason that Themelli identified, common law, legal profession, and the judiciary. So the common law in terms of its flexibility, in terms of its pragmatism, its business focus, has been developed, particularly with an eye over the years, to the needs of the business community, to keeping up with business developments. Competition exists there now in respect of, say, for instance, Singapore, which markets itself as having a more effective contract law in certain circumstances than in England and Wales, and particularly if you look at commentaries regarding interpretation of contracts, the Singaporean view is that the approach that they take is much better, more effective for business in terms of clarity and certainty than the approach now taken here. So common law wants an advantage, historic advantage, perhaps now with its competitors. Legal profession, the judiciary, well, the other reason, quality of the legal profession, has historically been viewed as a reason, and again, Themelli's study produced results which suggested that from a business perspective, qualitative comparisons across legal professions in different jurisdictions plays a significant role within choice of jurisdiction, and the same with the judiciary, quality of the judiciary, particularly in the commercial court. And that, of course, takes us to the third reason, the development of the commercial court. Created in the late 1800s, particularly as a response to, do we know what it was a response to? The needs of the market. Why was it a response to the needs of the market? Because businesses were taking their disputes to English-based arbitration rather than the courts. And the courts wanted to claw the business back. So the commercial court was invented towards the end of the 1800s as a means to compete effectively with arbitration, to provide certainty in the law, to provide an effective forum for litigants to get their rights determined effectively, rather than having to go to arbitration. So developing a commercial court, again, as a response to the needs of the market. So market-focused. And since then, the commercial court has been maintained, reformed at numerous points over the last 120, 150 years or so to ensure that it kept pace with the market. And I'll come back to that later on. And finally, why? Well, because of courts' promotion of something that doesn't really necessarily always happen in courts, alternative dispute resolution. So we see particularly within commercial and business disputes, particularly the development and early promotion of ADR. You'll often be told, particularly if you read the American literature, that early neutral evaluation, a form of evaluative ADR which takes place at an early stage in disputes, particularly in commercial disputes, was pioneered and developed in California. Unfortunately, that isn't true. It was developed in the 1930s here by the chief judge or the senior referee in what is now the Technology and Commercial Court. It was a response to the needs of businesses to resolve technology disputes, construction disputes, more effectively, more efficiently, more speedily, if we recall Denning earlier. So we see pioneering, innovative developments to add a wider range of mechanisms to resolve disputes. We also see the development and support of arbitration, where the courts take an approach where they support as much as they can and they leave arbitration alone as much as they can as well. So again, a link between the courts, commercial court particularly, and arbitration. And finally, we see the other reason from the late early 1990s, the development and promotion of ADR more generally as a mechanism to resolve commercial disputes. So it's providing a holistic, we might say now, approach to dispute resolution. So those are the reasons why commercial dispute resolution developed here, I would suggest, as a centerpiece of our courts. But what are the challenges? So there are probably 4 challenges at the moment. The first, which has been going on really for the last 5 or 6 years, is what Formelli described as the great race of courts. So we've seen since the middle of the 2010s, really. Oh, actually, that's nearly 10 years now, isn't it? Doesn't time fly? Gosh, it shows I'm getting old. Okay, since the middle of the 2010s, we've seen the development in a wide range of jurisdictions, both in Europe, in the Far East, in the Middle East as well, of courts and arbitration centres, all of which explicitly or implicitly, depending on their perspective, are competing with the established commercial courts and arbitral centres. So, as an established commercial court and arbitral centre, London is facing competition, significant planned competition for the first time. And we particularly see this in terms of Qatar and Dubai, and also probably most significantly Singapore as well, with its international commercial court and its international arbitration offering as well. So we see greater competition. Greater competition means where disputes are mobile and international business disputes are mobile, they can go anywhere. We can see now the prospect of losing work from here to those other jurisdictions. So a challenge on a competitive basis. The second one, and this is part of that challenge, is what I would describe as the Singapore model of commercial dispute resolution. So in Singapore, there has been a concerted, try not to break the computer, there has been a concerted effort over the last probably 10 years or so to develop in a structured, in a strategic way, its dispute resolution offering for commercial companies. So the development and introduction of its international commercial court, the link that has to its international arbitral centre, and now with the Singapore Convention coming into effect in terms of mediation, we're going to see now a much more integrated approach to mediation for commercial disputes as well. So we're seeing a 3-pronged development within Singapore, which is backed by significant investment, and both in terms of the judiciary and in terms of the government there, to ensure that it has the most significant offering in terms of dispute resolution. So that's a significant challenge, not just from Singapore, but also, probably more importantly, from the idea of an integrated approach. We may have innovated here in the 19th century to introduce the commercial court, but we haven't really innovated since then in terms of how to integrate links between commercial courts and arbitral centres and mediation in the same way. We don't have a strategy at the moment, for instance, to respond to these challenges, either the general great race of courts one or the Singaporean model. So we're perhaps slipping back because we don't have somebody, and I'll come back to this, we don't have somebody coming up with and developing a strategy. Third problem, you could call it the Brexit dividend. It isn't a beneficial dividend. It's been the loss of the ability for the free movement and the free circulation of judgments across the European Union, because we're no longer part of the Brussels or Lugano regimes. That has one consequence of that has been, if you wish to have a nicely free-flowing judgment within Europe, you wouldn't litigate in the UK. You wouldn't bring your disputes to London. You would, as is increasingly the case, go to Paris. And the next consequence of that is not just in terms of judgments, but also in terms of contracts. One of the reasons why commercial dispute resolution was beneficially based over here in terms of our courts was because contracts, particularly international commercial contracts, were based under English law. Now we're seeing, as a consequence of Brexit and the non-recognition and enforcement of judgments circulating around the European Union, we're seeing contracts now being drafted under French law, French contract law, for instance. So we're starting to lose the subtle promotion, you could describe it as that way, of English law and the English jurisdiction as a jurisdiction of choice, because we're not having recognition and enforcement, and as a consequence, contracts are changing, and standard terms contracts become the ones that everybody uses. There is possibly a way around that, with the Hague Judgment Convention coming into force here at the end, in January next year. But the extent to which, having lost ground, we will be able to make that back up is an open question. And the fourth challenge is digitization. How well are we doing it? How well are we modernizing our courts? I'm going to come back to that, but the answer is perhaps not as well as we might like to think, or we like to tell ourselves. So, where do we go from there? So how do we respond to the challenges? Well, the first way was identified by Lord Thomas, who's the former Lord Chief Justice, in the Hamlin lectures that he gave just before Christmas last year. And towards the end of his final of the 3 lectures, he suggested that leadership was required. Now, if we take the Singaporean model, which I mentioned a moment ago, there is clear leadership there. The leadership is provided by Chief Justice Menon and widely supported by the Singaporean government. Where is the leadership here, he suggested? Where is the leadership from the judiciary, from the legal profession, from the government? Is there joined up leadership, if there is leadership at all? Where is it? He raised the question, and I think the subtle implication was that he didn't see that there was leadership. That's arguable, but his implication was there isn't, and we need it. That certainly seems to be the benefit in terms of how things are developing in Singapore and in other jurisdictions where they're developing their commercial courts and commercial arbitral centres. The second thing we need to think about in terms of responding, do we need a governance strategy? There is no real governance strategy at the moment which looks at litigation, mediation, arbitration. We're reforming the Arbitration Act at the moment, but we're doing it in isolation from reforming the courts. We're doing it in isolation from reform or promotion of mediation or other forms of dispute resolution. Where is the strategy that brings it all together, that governs it? Chris Hodges, who occasionally talks about this, has argued that we need an overarching governance strategy run perhaps not by judges and not by government, but by interested stakeholders, civil society, as well as government, as well as the judiciary. Because if you just focus it on the government, if you just focus it on the judiciary, what you end up having is a governance strategy that focuses on their particular ideas and their particular aims and goals, rather than necessarily the ones which are best for a more rounded development. Hence, as in Singapore, it might be Chief Justice Menon, but it's also driven by the government as well. There is an overarching strategy there. So, first 2 points, leadership, strategy. Next point, we need to learn from others. We used to be very good at this. The development of commercial law and commercial dispute resolution was very much developed by Lord Mansfield. Yeah, we remember Lord Mansfield? Yes, you may have read some of his judgments, particularly if you've done unjust enrichment, if that's what it's still called. So, developed commercial law, insurance law, as at the time he was Chief Justice. no real problem at that time of learning from what was being done in other jurisdictions, in learning what was being done in terms of international mercantile law, in learning from Justinian, for instance. So adopt the historic approach. Learn from others. So in Dubai, they're taking an integrated approach. They've come up with an idea, a novel idea, to enable court judgments to be transposed into arbitral awards to make them easier to enforce under the New York Convention. So if your judgment isn't easily enforceable in another jurisdiction, can you use the process that they have created to convert it into an arbitral award and render it easily enforceable? So can we learn from them? At one point it was looked at, it was mentioned, probably in around about 2015, but again, no overarching strategy, perhaps an absence of leadership, maybe. I'm not saying there is, I'm suggesting. Didn't take it any further. So again, next one, Singapore again. Singapore's getting a lot of mentions today. I don't know why. Singapore, closer connection between your commercial court and your arbitral centre. Let's actually think about how they can work together in a much more explicit, connected way, as they're doing there. So learn from them. And then let's also see if we can learn from the US. In the US, they have a mechanism, particularly in California, but in other states as well, where they allow private judges to act, particularly in commercial cases. Could we not use that here? Might that enable commercial parties in disputes to identify, just as they would with an arbitrator, the person who they want to be a judge, appoint them, pay for them, just as they do in the United States, and then as a consequence, not just get expertise, but also get flexibility, also get timeliness, because they can then choose when the matter is heard. They don't have to wait for court listings. They don't have to wait as part of the court timetable. Can they effectively take the benefits of arbitration, marry them to the benefits of litigation, and have their disputes resolved more effectively, more speedily, as Denning identified? So could we learn from them? It's always possible to learn. What about maximising opportunities here? So I don't know, should I ask this question? Have we heard of Churchill and Merthyr Tydfil? Any hands up? No? Okay. So in 2004, the Court of Appeal... we've got a nod at the back. Yes? Okay, in 2004... Sorry?
It's an old memory.
It's an old memory. Okay. So in 2004, this is an old memory, 2004, 20 years ago, the Court of Appeal in a case called Halsey and Milton Keynes said, you can't force parties to mediate or use another form of ADR. You can't have mandatory alternative dispute resolution. That was a huge mistake and has affected adversely the development of ADR here for 20 years or so. In Churchill and Merthyr Tydfil, just before Christmas, the Court of Appeal rectified its previous mistake and said, actually, that case was wrong. You can mandate the use of alternative dispute resolution. And as a consequence of that, I imagine we're going to see a new flourishing of alternative dispute resolution over the years to come. Now, if we're going to take advantage of that, and perhaps we would want to, what we could do is, in the commercial court particularly, start to train and promote the use of judge mediators. There's no reason why not. There's no reason why they can't be trained. And judges in the commercial court can act as arbitrators at the moment as it is. There's no reason why they shouldn't be able to act as mediators as well. So have that as an additional string to the arsenal. Equally, we could start to develop perhaps Michigan, what's known as Michigan mediation, where you have the mediator, and as the mediation goes on, the dispute is then referred to a bank of 3 lawyers who give an opinion on the merits. So you have a facilitative mediation, and then you have an opinion, an evaluative opinion as well. To again help, so could we incorporate that into the system? Might we want to link this, here's your governance strategy, with the Singapore Convention? Might we want to think about how we can promote that through the use of commercial mediation, mandatory perhaps commercial mediation? And then, might we want to experiment? Judges know how to carry out early neutral evaluation. We could train them to carry out mediation. Could we not start to innovate and start to marry the two together to gain a more effective mechanism, ENE-MED? We've heard we have well-established ARB-MED, MED-ARB. Why not start to use ENE-MED as well? So are there things that we can do based on court decisions here within the commercial court to develop our offering more effectively? Don't just look at what's happening here. Don't just look at what's going on abroad. What does the market say? So in 2016, Mr. Justice Blair, who at the time was head of the Commercial Court, made the point, the obvious point, that international commercial disputes, they're mobile, they can go anywhere. Well, if they can go anywhere, there has to be a reason for that. So let's find out what their reasons are. Listen to them. Historically, we used to listen very well. So if we go back to Lord Mansfield again, he was always listening to what was being said by the insurance industry, by the business industry. He would often have dinner with them. I don't think judges now could be having dinner with litigants and with market actors. That might not be viewed as appropriate. But there's no reason why, through the use, for instance, a more widespread use of the commercial court users group, that they cannot get more effective and better feedback, that they can't gain an understanding, a more up-to-date understanding, and then respond to it of what's going on in the marketplace. Why are businesses choosing to go elsewhere? And then digitization. So digitization is an interesting thing. We've been doing it now since 2015 seriously as part of the Modernisation programme here. Other jurisdictions are equally doing the same thing. If you're in China, for instance, they have very well developed internet courts and internet court offerings. If you go to other jurisdictions, they have equally effective development of digital processes, filing systems, for instance, management systems, digital hearings. We are often told here that we have a world-class one, that we have the best in the world. Without wanting to be controversial, I think we can question whether it is, or whether it has been slightly lacking. We've been attempting to digitize since 2015. To give you an example, in Canada, this isn't commercial dispute, but in Canada there is what's known as the Civil Resolution Tribunal, which is fairly digital, and which was the model for the modernisation programme here. It's almost 10 years old in terms of its operation. I think it's probably older than 10 years old now. It's doing really well. It's growing. It's continuing to expand its remit. No doubt at some point it will expand its remit to cover low-value, small-scale commercial disputes and then probably larger ones. At least you would imagine that that is the trajectory. When we devised our modernisation programme, that, as I said, was the model. It was up and running at the time in Canada. That was in 2015. Ours isn't up and running now. So they in Canada had a system that was up and running. We took it as our model. We decided we would design our own version of it. We are still not there with the functionality that they have in British Columbia in Canada. But yet we are often told that we are world leading. I'm not entirely sure that we are world leading, because if you look at what's going on elsewhere in the world, they're already doing it or they're doing it better. So I think perhaps a little bit of humility and a little bit of greater willingness to see and learn from what's going on outside, learn from others, we might start to do a little bit better. So we can see in some places that we are learning. So if you saw guidance on artificial intelligence and use by the judiciary, generally was issued here before Christmas, almost on the same day. The very similar guidance was issued by New Zealand. I can't believe I don't know this to be true, but I can't believe there wasn't some communication between the two in terms of the drafting. I wonder if you put it through ChatGPT, whether it would be able to identify similarities, or turn it in, for those of you who remember, anti-plagiarism software. Not that I'm suggesting, which I am not, that there was any plagiarism, just saying that there was arguably, you could think, influence. Equally, we see guidance on the integration of ADR and ODR as well. That was issued a number of years ago now by the European Network of Councils of Judiciary, by the European Law Institute. That has definitely influenced the development here. We can see that in the language of the Churchill and Merthyr Tydfil decision. So we are learning in some areas. We are learning from elsewhere, but not necessarily as well as we could. And then we need to ask ourselves, if we are digitising, to what extent is it helping or is it wanted by commercial parties? Now, one of the things that was interesting coming out of COVID was the use of remote technology and remote hearings. And we saw that effectively becomes the default, or became the default for a time. And a lot of people thought that that default would remain the case, as long as the technology is there to support it. But one of the things that we noticed in the commercial court, and this is set out in the minutes of the Commercial Court Users Committee, is that lawyers acting for commercial clients were not necessarily as keen on the use of remote technology and remote hearings as you might have thought they would be. And the reason, interestingly, the reason that was given was that the use of remote technology in a remote hearing, when you're not there, you're not in the same room as somebody, you're not in the waiting room in court, you're not able to go up to your opponent and talk to them, you're not able to watch the body language of your opponent and their clients because you're not across the room from them, undermines the ability to have informal discussions between the parties and to promote settlement. So we start to see adverse effects through the use of remote technology on other aspects of the litigation process. Now, Gallanter, a long time ago now, described the intrinsic link between litigation and negotiation as litogatiation. They are symbiotic. So we see, though, or at least it was suggested in the Commercial Court Users Committee minutes, that symbiosis was coming apart, that it was harder to negotiate because you lose the informality of a real-world, in-person setting. So perhaps, even if we get digitisation as well as other jurisdictions are, perhaps too much digitisation might actually undermine the efficacy of dispute resolution in our commercial courts. And again, is there an overarching plan? Now, Neil Andrews, who used to be a professor here, once said that the key thing for any effective dispute resolution system, he was talking particularly about class actions, was you need funding, you need the money. And if we're going to maintain the commercial court, the arbitral centres, if we're going to have an overarching strategy, a governance structure, we're going to need funding. A proper level of funding both to ensure reform takes place effectively, arguably not with the digitisation programme, £1 billion gone, and we're not finished yet with it, and we were only supposed to spend, I think, 1.2 billion. As I break the computer. Are we going to have that funding provided? Is it going to be maintained? It's not just the question of providing it initially, we have to maintain it as well. And I think there's a particular view that where modernisation and digitisation of the courts is concerned, all you needed was the funding to get things up and running, and then it would be much cheaper to run as a consequence of that when you have a new digital system. Forgetting, of course, that digital systems need to be updated, they need to be kept secure, they need trained people to maintain them, and all of that comes at a cost. To what extent has that cost been factored in? To what extent is the funding going to be there in the future? So, I leave you with Tom Cruise. A nicer person to be left with I can't think of. Thank you very much.